How often do you get deposed or called to testify when it comes to surveillance investigations? Welcome to the PI Guide channel, tips, tricks, and advice for professional private investigators. My name is John Morris. I am a licensed professional private investigator. Bent Roeder, a good viewer here on the channel, recently asked me that very question. How often do you get deposed or called to testify when it comes to surveillance investigations? And what a great question it is. And if you have a question for me, go down in the comments and let me know what it is. While you're down there, let me know how often have you been deposed or had to testify in a surveillance case. I would really like to know. A deposition, for all intents and purposes, is a question and answer session between the attorneys involved in a lawsuit and a witness. The witness of a deposition answers the attorney's questions while under oath and is often recorded by a court recorder. This recording may be written, audio, video, or any combination of the three. Something to be aware of is that most depositions are often held in one of the attorney's offices. This can make the entire process seem to be rather casual. However, you are giving sworn testimony under oath, and what you say can be used against you. Attorneys will often use depositions to prepare for trial, and the results of the deposition can in fact be used in court. Some of the reasoning behind depositions is to discover what you know about the case, find evidence favorable to one side or the other, or commit you to your statements under oath. An attorney may also depose you to try to discredit you and use your testimony or discredit other witnesses involved in the case, or to see what you look like, how you speak, and how you will represent yourself to a jury. Given all of that, preparing for a deposition correctly is vitally important. You must be prepared for opposing counsel to emphasize the strong points about their side and try to poke holes in your testimony. Opposing attorneys may ridicule your story. They may contrive ways to suggest you are not being honest, and they may try to put words in your mouth. And this is true whether you are under oath at a deposition or taking the stand at a jury trial. As you can see, being prepared for a deposition is crucial in all cases. You need to ensure you review all, keyword, all the facts of your investigation with the attorney who is representing your side. Make sure your memory about the case is fresh. Make sure you answer questions correctly and look for weak spots in your own investigation. Did you see the defendant lift the bag of dog food and place it in the trunk of the car, or was there a visual obstruction and you assumed the defendant placed the dog food in the car? What does your video say about that situation? What does your report say about the situation? Make sure you take time to think before answering questions. Let me say that again. Make sure you think before answering. Do not assume you know what the attorney will ask you halfway through the question and blurt out an answer. Listen closely and carefully to each question. After the attorney is done, then pause a moment. Think your answer through in your mind. Then articulate the answer in the shortest, most factual way you can. You need that pause before you answer for three reasons. The first is to make sure you understand the question that was asked. The second is to give you time to formulate the correct answer. And the third is to allow your attorney time to object if needed. Another good tip here is to make sure you never ever give away or volunteer information. If the attorney asks you, what did you see the defendant do at the bar on Friday night? Your answer should be only the things you saw with your own eyes, what the defendant did at the bar on Friday night. Don't say what you saw the defendant do at 10:30 that morning. Don't say how the defendant drove to the bar. Don't say how the defendant walked into the bar. Just say what you saw the defendant do in the bar on Friday night. Volunteering information can open up a virtual Pandora's box for the opposing counsel and lead them down cross-examination paths they never thought of before. This goes the same for closed-ended questions too. You know, those questions that require a yes or a no. Just answer yes or no. Do not offer qualifiers. You do not need to explain the answer unless the attorney asks you to do so. This is one of the biggest problems I have seen with PIs when giving testimony. The attorney asks a simple question. Mr. Investigator, did you see Mr. Defendant pick up the bag of dog food from the shopping cart and place it in the trunk of the car? The investigator answers no, but you see, the trunk was open and I was parked on the other side in front of the guy's car across the parking lot, and I had very limited visibility due to all the cars and people and other obstructions. It was a very tough situation, you know. Thank you, Mr. Investigator. So you were saying it was difficult to see what was happening in that parking lot. In fact, it was probably hard to even tell if anyone was with the defendant or not, or if someone else placed that 50-pound bag of dog food in the defendant's car. Now, the attorney is not really asking you a question here. He is putting words in your mouth, and your attorney is forced to come up with objections, and you are going to feel the need to defend your statement, and the rabbit hole just keeps getting bigger and deeper. Another word of wisdom is make sure you understand the question asked. I already said to listen. Let the attorney finish the question and think about it, but you also need to be sure you understand the question. If there is any doubt of understanding, then you need to ask them to rephrase it differently or clarify the question. One of the worst things you can do is give an answer to a question you thought they were asking, but they're actually asking something entirely different. Mr. Investigator, what did the defendant do when he got to the rear of his car at the grocery store? You might be prone to answer something like he put the groceries in the trunk of the car, then he got in the car, then he left, and he went home. But the question was, what did the defendant do when he got to the rear of his car at the grocery store? A better answer may be something like he took his car keys out of his pocket, or he unlocked and opened the vehicle's trunk. So more big things to keep in mind here. Don't get rattled and don't get upset. The other side is just doing their job, and they're often in a deposition trying to see how you will present and react if you are put up on the witness stand. If opposing counsel thinks you will have a tough time on the stand, have a breakdown, get flustered, do anything to allow them to discredit you, I can guarantee you that you will be called to the stand when it comes to trial. Silence is golden is always a good rule of thumb, and this goes for giving testimony during a deposition too. After you answer the question, stay silent. I know it can get quite awkward at times as everyone is trying to decide what the next move is. Sometimes opposing counsel will use that silence to see if you offer up any more details. So just zip it, think of pleasant thoughts, and let them make the next move. If you're asked a question and you do not remember, just say so. Don't try to guess, don't stumble around, don't rehash the entire investigation out in your mind. Just state you do not remember. If you are pretty sure you know the answer, but you are not absolutely certain, then state that too. Mr. Attorney, I think I saw the defendant put the dog food into the trunk of the car, but I am not absolutely sure of that. This allows your attorney to object if needed, or sometimes even ask if you would like to review your report to refresh your memory. Now, one thing to remember, your report may not already be a part of the court record. So, if your attorney allows you to see the report for a refresher, well, now it will be a part of the official court record, and I will discuss the importance of that in just a moment. Remember, you are not judge or jury. You are the finder of the facts in all situations and to all questions. Tell the truth, don't guess, and stay true to your answers. If they ask you a question once and you answered it truthfully and then they ask it again, stick to your answer. There is another ploy to see if you stumble or answer a question differently. And this is another reason for those pauses before your answer to give your attorney time to object because you have already answered the question. Make sure you know what your report included, what photos you provided, and what the video includes. This is very important. And if the attorney asks you about anything, a photo, a part of your report, anything, do not be afraid to ask to see it for yourself. They could be referring to a photo of the location of an accident scene that their investigator took. They could be asking about something that is zoomed in or blown up from one of your photos. They could be referencing an incident report, a police report, or some other report besides the ones you provided. Make sure you get to examine it carefully and you understand fully what they're asking about. And if it's not your report, make sure you state that too. I know that reviewing all of your files can be a very time-consuming part of deposition preparation, but it is also a necessity for that preparation. I have had cases where I had hours upon hours of video on surveillance cases and many reports that I wrote over the entire case. I always let the attorney know what I will need for prep time, the importance of that prep time, and the fact that I will charge for the time accordingly. If I have 1 hour of video, I will want to review that video at least twice while I also go over my reports. So I may be billing them for 3 to 4 hours of prep time. This brings me to another huge thing to mention. Do not bring documents with you to the deposition unless you are subpoenaed to do so. Don't bring notes. Don't bring copies of your reports. Don't bring photos or video. Don't bring anything. Remember, your entire record of the investigation is privileged and confidential work product. The other side, they may not have ever even seen it. And if they haven't seen it, well, there is a reason your attorney has left it out of the record. Here's a quick word about the questions you will be asked during a deposition. Not all questions will be or seem to be relevant to the matter. The deposition may oftentimes go beyond the scope and be very broad in nature. A deposition is used as a discovery tool. The attorneys are looking for evidence, and they may even go into personal areas of your life in their questioning. Are you married? How many children do you have? Have you ever been arrested? How long have you been a PI? How many times have you taken the stand as a witness in court? They may also ask baseline questions too. These are easy questions. These are questions they already know the answers to. These are questions they will use to get a baseline reading of how you react and answer questions. After the deposition, you should be given the ability to review the transcript for the deposition and make corrections to mistakes. But keep in mind, the best time to make these corrections is before the transcript has ever been written. Raise concerns to your attorney about anything you may have answered incorrectly or forgotten to mention. And the best advice of all is to relax. I know it's easier said than done, but try to stay relaxed, stay comfortable, and stay focused. Remain confident in the fact that you know your investigation inside and out and your answers are truthful. Now, how often have I been deposed or had to take the witness stand regarding a surveillance investigation? Maybe a handful of times or so over the years. I have had to testify a lot regarding criminal cases, but it seems surveillance cases are less often, especially if your reports are done correctly. And I made this video right here that goes into depth about what your reports should and should not include and how to write them. So check it out now.